My name is Aayushi Mishra. I'm an LLM student, and I'm here to present and introduce, actually, a very exciting panel. Does AI exist in our world, or do we now exist in the world of AI? As of 2026, the answer seems increasingly to be the latter. Artificial intelligence today shapes how we think, work, and inevitably resolve disputes. The question then is not whether AI belongs in arbitration, but how far are we willing to let it in? What does this mean for arbitral institutions and arbitrators? Can party autonomy extend to choosing not just arbitrators and applicable law, but also the role of AI in proceedings? At what point does efficiency give way to ethical concern? Should counsels disclose their use of AI? And if so, when? And perhaps the question quietly on every junior lawyer's mind, are we replaceable by AI? To help us navigate these questions, we are joined by an exceptional panel of practitioners and thought leaders who bring perspectives from across the arbitration spectrum. We have Professor Berger, a highly experienced international arbitrator who has served on numerous institutional and ad hoc international arbitral panels. He's also a professor at the University of Cologne, Faculty of Law, and has been the former chair of the German Arbitration Institute and member of the ICC Institute of World Business Law Council and ICC Commission on Arbitration and ADR. Interestingly, he's also one of the 4 permanent arbitrators for contractual disputes between drivers and their teams in Formula One racing. We have Mr. Jeremy Sharpe, independent arbitrator, board member of United Nations Register of Damage, and also a lecturer in law and senior fellow at our Columbia Law School. Mr. Sharpe was earlier a partner in Sherman and Sterling's international arbitration and public international law practices in London and Paris. He has also served as legal advisor to the US Embassy in Baghdad and was the chief of investment arbitration at the State Department. We have Mr. John Fellis, a full-time international arbitrator who was formerly co-chair of the International Arbitration Group at Hughes, Hubbard & Reed in New York, where he practiced for over 30 years. He was recognized as Best Lawyer in New York for International Arbitration by Best Lawyers and Global Elite Thought Leader by Who's Who Legal, and also awarded the 2025 Global Arbitration Review Award for the Best, Most Responsive Arbitrator. Joining them is Mr. Felipe Nazar, partner in Akin's International Arbitration Practice in New York, whose practice encompasses international, commercial, investor-state, and treaty-based arbitrations seated throughout the Americas, Europe, the Middle East, and Central Asia. He's been recognized as a future leader in international arbitration by Lexology Index. And finally, the discussion will be guided by a moderator, Mr. Rahim Moloo, partner and global co-chair of international arbitration at Gibson, Dunn & Crutcher, and a valued member of our Columbia Law faculty. He's on the board of directors for the International Center for Transitional Justice, and his book on procedural law and investment arbitration, published by Oxford University Press, has been dubbed by the Secretary General of ICSID as being a go-to guide for investor-state dispute settlement. With that, we invite you to consider not just how arbitration adapts to AI, but how AI might in turn reshape arbitration itself. Please give a round of applause for our esteemed panel.
Thanks, Aayushi. I have to, was thinking about how to introduce this panel. And, normally in AI panels, some people go to AI. I didn't do that. Some of my panelists will be happy to know. But as we now all go to conferences around the world, there has to be the requisite AI panel. This is it. For those of you who obviously are here in the room, But the interesting thing about AI panels is they've evolved over time. And I think hopefully you'll see that this is the case with this particular panel, because it's no longer a question of, is AI going to change arbitration? What are the ways in which it's going to be used? It's here. We're all, I think, a good portion of the folks in the arbitration community have used it in some way, shape, or form. And the question really is, what do we do now? How much, as Aayushi said, do we let it in? The questions about regulation, but what we thought we'd do is collect thoughts from some folks who have thought about the issue, and I can say with with some nuance and really have some, hopefully, insightful views to share with all of you today, to think about it from the perspective of arbitrators and institutions. How are arbitrators using it? How are institutions using AI? And how will they in the future? Counsel, how is counsel using AI? And clients and parties. And for better or worse, how they're using AI, how it's going to impact what we all do as counsel and arbitrators. So with that, we'll kick off with the first of those categories, institutions and arbitrators. As an initial matter, again, like I said, AI is already being used probably in ways that you all didn't appreciate. And so to kick us off, Klaus, I'll ask you to offer a couple examples of how AI is already being used to make decisions.
Yeah, thank you, Rahim. Before I do that, I have to say also, or express my sincere admiration for Judge Berman. He invited me to teach here in 2014, and it was a real academic thrill for me. And the degree of thrill, I think you can imagine that by understanding that the poster with which my lecture was announced in 2014 here is still glued to the door of my private office in Cologne. Now, coming to my subject, I wanted to introduce you to OLGA and FraUKe. OLGA and FraUKe are two AI tools which are used by the German courts. It is very surprising because I can tell you that German courts are not known to be very innovative or progressive. So there must be a certain reason why they have left these courts their comfort zone and have developed these AI tools. Now first, OLGA. OLGA was developed by the courts in Stuttgart. Stuttgart and Munich are the seats of the major car manufacturers in Germany. And as you know, we have the famous or infamous emission scandal problem, Dieselgate, as it's sometimes called. It started here in the US, as you may know. And there are hundreds and thousands of cases pending before the courts in Stuttgart against all these car manufacturers by dissatisfied buyers of these cars. And what OLGA does is it does not assist the judge in rendering its decision, but it derives data from the briefs submitted to the court in order to create categories of cases. Now, these categories of cases are determined by the identification number of the car, the year it was built, the engine type, and all these wonderful data. And so what happens is that OLGA categorizes all these cases so that the judges can then deal with the cases in groups, in categories, rather than having to do that themselves. So this is just a tool to assist the judges in Stuttgart. The second one is FraUKe, or FraUKe as you would say, and the translation would be the Frankfurt Digital Judgment Configurator. What is this? This is also caused by the problem of huge numbers of cases before the Frankfurt courts, cases on air passenger right claims, because you know we have the big airport in Frankfurt and we have the seats of many of the major air companies in Frankfurt, and so they are being sued by customers who are claiming damages from them, and sometimes these claims are bought by legal tech companies or financial institutions, and they are then flooding the Frankfurt courts with these cases. And so FraUKe is indeed preparing first a draft of these judgments after having derived the relevant information and data from the briefs that are submitted in a digital form. But it's very important to emphasize that there is still a judge in the loop. So the final judgment will be rendered by the judge himself. He's just aided by this FraUKe tool.
And by the way, some of you may know that, for example, in China, I was on a panel, an ICA panel 2 years ago in Hong Kong, and I was shocked to know that already, at that point in time, in China, the Shenzhen Court of International Arbitration and the Shanghai International Arbitration Center were already using AI. So for example, for financial disputes, to recover a debt, basically the claimant would upload its documents, the respondent would upload its responses, AI would prepare a summary of the procedural background, a summary award, and the arbitrator would basically come in to like confirm the outcome before the award was issued. But that was already happening a couple of years ago in China. So international arbitrators, AI in some sense is already performing at least some of the functions of arbitrators. Some of you may have seen the AAA just released its AI arbitrator tool for construction disputes.
Just a comment about the AAA AI construction tool. And before I go into that, I also want to express thanks for being here in honor of Professor Berman. I did note earlier that Her Excellency from the French Ministry said she would look into French citizenship for him. I suspect there's some other people here from New York that might be interested as well. So do try and find me afterwards. In terms of the AAA's AI tool, it's for small value cases, it's for small value construction cases. And I remember before it went into effect, being at a conference where it was announced by the Chief Technology Officer of the AAA, and I put up a question. I put up my hand to ask a question. My question was, does it ask any questions? And she said, well, no. And I thought that was very odd. I don't think I've ever been involved in an arbitration where an arbitrator hasn't asked a question. And one thing that worries me is that these AI tools are being developed by the technology folks because they understand the technology without actually talking to the arbitrators who live the life of deciding cases. It really made no sense to me that it wouldn't ask questions. But anyway.
Anybody else have anything to say about that?
Yeah. Hello, yes. First of all, thanks for the invite. It's such an honor to be in such a special day, joining Columbia for the second time, and for the second time moderated by Rahim. So, good too. And I have been thinking, as we have been discussing because in a way, like for example, what do we know about the AAA exercise tool? Presumably, it was trained under, a common law approach. And then, just on those two elements, one could say, well, 1,500 cases is not really a lot. It's something, but it's not a lot. And, that it was trained under common law, understandably, because it's the AAA, but also, common law has such a different approach to civil law, for example, in so many things. For example, with the interpretation of a contract, where in common law, you would be very much tied to the language, while in civil law, you would have more leeway to incorporate elements of good faith and so on. So do we know really how that is working? Possibly not. And then today, the exercise is easy, like, for matters at an airport or construction or, what you describe in China. But say we think, a little bit further and say, well, let's use it in an investor state case. We know how difficult it is to just define fair and equitable treatment. There have been, hundreds of decisions describing it differently, and the nuance really matters. And I am not sure that nuance in this case can really be achieved by the tool. And then in the different examples that have been discussed, there is also the point that the AI produces a summary of the facts, a summary of the claims, a summary of the defenses. But how many in the room have been experimenting with whatever tool you use, and the bot gets it totally wrong? I'm sure that many. So when you have a summary prepared by a tool, you may be dealing with a bad summary, and then you have to fight both the tool and your opposing party. And then you also have the risk of anchoring bias, because the tool came up with a solution, then you are correcting it, but in my experience, there is still a risk that the tool will want to go back to what it thought to begin with. And then lastly, we take quote-unquote comfort on the human on the loop situation. But really, unless the human in the loop is reviewing the documents in the same fashion as the tool, which is supposedly not the idea, it is impossible that human in the loop will have a meaningful comment or challenge to the summaries or the conclusions that the AI tool achieved. So how is it that that human with little knowledge, with mostly a formalistic role, will go and say, no, you got it wrong, and let me rewrite the word? Well, I will have to see if that actually works like that.
Yeah, I think, this one? Yeah. I mean, to John's question, does it ask questions? Why do arbitrators ask questions? One of the reasons why arbitrators ask questions is because, as much as counsel think we're doing a great job at, interrogating all of the issues, there are sometimes gaps, or we may not have thought about something, or there are legitimate questions that require further interrogation by the parties. And so the assumption that AI is making is that everything it needs to know, the universe of information it needs to know to make a decision is there. Whereas that is, I think, a really telling question and answer, because we know that's not always the case, because otherwise there would be no, well, sometimes arbitrators ask questions just to test things, or they may not have done all the reading, but that's certainly not the case with the people up here. So, there is an element that is certainly missing. Jeremy, I don't know if you have a view on the AAA approach, or another interesting example I know that you've had some exposure to is the Ukraine Register of Damage. So we've talked about some of the downsides or risks, but in some cases it may actually, I don't know if that's your view, but help us in being able to aggregate or deal with really large amounts of claims.
Thank you, Rahim, and thank you for the invitation to be here. I, too, want to pay tribute to Professor Berman and his long, illustrious career. He, like myself and others here at Columbia Law School, were involved in advising the government of Ukraine on the establishment of a register of damage for claims arising from Russia's aggression. And there was an early sense that this species of mass claims processing could employ AI techniques. If you think about these kinds of mass claims, you have hundreds of thousands or potentially even millions of claims. You can't individually adjudicate these. This is more claims adjudication than claims administration than claim adjudication. So you have lots of claims. You often have the same or similar measures that affect the victims. You have related claims. So for instance, a claim of an employer for the loss of his business can be related to the claims of the employees who have lost their employment. So there are these abilities with these kinds of mass claims to use digital technologies. This is, as far as I know, the first all-digital, paperless mass claims process at the international level. You can file a claim on an app. It's the government DIA app, which itself is embedded with other information, like national identity numbers, property records, and so already your claim can be checked against other existing sources, the way that you need to do in a mass claims process. Translation, these are all things that can be done through these kinds of techniques. So here, I do think it was expected that AI could play an important role and will. I would contrast that with another register of damage that I'm involved with, which is only 20 years old, the United Nations Register of Damage for Palestinian claims arising from the construction of the wall. Even though it's only 20 years old, it's like a different technological universe, right? Paper claims with individual claim intakers going person to person and village to village, community to community to take claims, physically translated, sent to Vienna, processed, and so forth. That's okay when you have 80,000 claims, say, but not when you have millions of claims, and it still takes years and years. There may be opportunities to introduce AI even to retrofit a process like UNRWA, so to say, but with the Ukraine register, which some students here at Columbia actually researched as part of a practicum, including the use of AI to help process these claims, I do think an all-digital register, mass claims, a different kind of claims administration process. It's called rough justice. You're not individually adjudicating claims. You have lower standards of proof, claims grouping, you have statistical sampling, these other techniques that allow you to efficiently process hundreds of thousands or millions of claims, but not to adjudicate them necessarily. So in that instance, I think we will see AI being developed, probably first in the Ukraine register, and maybe there are some spillover benefits for mass claims in arbitration, but as we heard earlier today with the discussion of Abaclat, that's a different discussion because then you have the issue of consent and whether Argentina, for instance, consented to a mass claims process by joining the ICSID Convention. But when you're dealing with mass claims in an international claims commission or a register of damage, at least some of these issues, at least not as precisely, will arise in that context. Thanks, Rahim.
So there was an interesting phrase I want to pick up on that you said, which was rough justice. Because I think there's a question about whether or not AI can deliver any form of justice, but I'll use that as a transition to my next question for all of you. And I think rough justice is a fair, I think that's a fair way to characterize it. But when would you say, and Felipe, you talked about consent, when would you say it is appropriate to use AI in the decision-making process? I mean, maybe it's an obvious answer, but from your perspective, either arbitrator or counsel, when do you think it is appropriate to use AI?
Well, consent is an absolute prerequisite, no matter what other condition there is. I think the parties have to agree that you can use AI in the decision-making process and be permitted to ask questions about precisely how it's going to be used. I think the point about rough justice is well taken because sometimes either you get a decision from AI or you don't get a decision at all because the value of the dispute is too low to actually hire a law firm and engage an arbitrator and so on. But I think consent is a prerequisite and the ability of the parties to inquire into precisely what it is you are doing.
And that makes complete sense. So let me frame the follow-up question slightly differently for the rest of the panelists, or you too, John. When do you think it would be appropriate for either the parties to say, hey, maybe this is one of those situations where we want to consent to using AI, or or do you think it would be appropriate for arbitrators to suggest, hey, maybe this is an appropriate circumstance for us to consider using AI for a portion of the dispute? When is it appropriate to be thinking about AI to make a decision? Anybody?
I think it's very, very difficult to answer that question in the abstract because you have to be confronted with a certain scenario in a certain case. And I would say, from my perspective as a practicing arbitrator, with respect to some jobs to be done by AI, I wouldn't be really concerned. Like, for example, providing a summary of the procedural history of the case in my award. I cannot see any problem with that. I wouldn't even see a need to disclose that. If you move from there to the summary of the facts, some people say, well, no problem there. I'm not so sure because everybody who has written an award knows that summarizing the facts is to a certain extent part of the intellectual exercise in rendering your decision. You may realize you have to change some things or rethink your reasoning. So there I have more problems. And in more general terms, if you want a general answer, the more I, as an arbitrator, move with the use of AI towards the actual decision of the case, the more I would be concerned and the more I would ask the parties for consent.
I want to draw a distinction that you didn't draw, maybe intentionally, because you talked about having AI make the decision. Now, there is a distinction to be made there. There's AI making the decision, and there's the arbitrator making the decision and having AI write it. Now, I find both to be problematic. And the second one, having AI make the decision absolutely needs to be consent, but I also think there needs to be consent also for the arbitrators making the decision and having AI write it. I suspect many arbitrators have had the experience of 3 arbitrators deliberating and reaching a decision after the hearings, and the chairman or chairwoman says, I'll go away and I'll write it. I had this experience more than once, where the presiding arbitrator came back and said, I just can't make it work. It won't write. And I remember in one case, I said to the presiding arbitrator, I'll write it. Just leave it to me. I'll write it. So I went away. I couldn't do it either. Once you examined the record and looked at the record and compared the contract language to the arguments, it just didn't work. The problem with AI is that it lacks that most civilizing of human virtues, doubt. It presents everything with utter confidence. And I guarantee if you go to AI and say, please write it up to come out this way, it will deliver something that looks fantastic and will nonetheless be deeply flawed. So I'm nervous about using it. Now, there are probably ways around it, right? There are ways you can say, listen, if you encounter any problems along the way, let us know, that you analyze the reasoning of AI carefully and so on. Fine. Maybe you will have arbitrators willing to go to that extra work. There was a recent article in the New York Times, slightly changing the subject, that raised the fear that AI was going to create antisocial behavior. Why? Because it always agrees with you. I'm having a quarrel with my neighbor. His branch is overhanging my garden. Oh, go and just chop it down, says AI. AI always agrees with you. And so even as an arbitrator, you write in, I think it should come out this way. You're brilliant, fellas. You're just absolutely brilliant. That is my experience with AI, and I don't use it other than in very limited circumstances as an arbitrator.
Just to add one thing, in a slightly different angle. Taking the distinction that John drew, I have also the question whether we are talking about the ultimate goal of an arbitration, which is to have an enforceable award. Because there are many reasons that would lead me to believe that if the decision is entirely left to AI, that would not be enforceable. We have the restatement, we have the Federal Arbitration Act, we have the New York Convention, all of them expressly or impliedly suggesting that there has to be a human involved. So to the extent we are living within that framework, we cannot even really have a serious discussion about having AI decide.
Yeah.
And then, sorry, just one last point. I also wonder if a human in the loop or an arbitrator kind of like validating what the AI decided would also be an award made by arbitrators.
So I was going to say exactly that. So now both you and John have raised an important point, which is with the human in the loop element, the thing you're still missing is the arbitrator really engaging with the record, and because they will feel like that has in part been done for them by AI. And we all know, whether it's counsel or arbitrators, until you really engage with the exhibits and the cases and you apply your mind to that, and actually it's really reassuring, John, to hear that that's a not irregular occurrence where the arbitrators go, look at the record, and they say, this award won't write the way we thought it would, because that is engagement with the record in a way that you want, quite frankly, your arbitrators to engage with the record, to challenge themselves, to ask. But if the human in the loop, I guess the question then is it, this is the question I was going to ask, which Felipe, you just asked, which is it ever then possible to say that you're truly getting a human rendered award if they're not engaging in that process?
I mean, formalistically, for compliance reasons, maybe, but I'm not even sure. Like, if you look again at the New York Convention, I find that you would struggle to argue convincingly that a human in the loop made an award. I don't believe so.
Yeah.
I think really we have to look at the timeline and where we stand and where we will be in, let's say, 3 or 4 years.
Yep.
We discussed it over lunch, because my feeling is that what AI gives us today is the illusion of human intelligence. It's just an illusion. Yeah, we have probabilistic algorithms and things like that, wonderful, but that is not human intelligent. AI today is not able to do value judgments and things like that. But I'm emphasizing the word today, and I said that also in our little debate that we had, because when we reach the level of artificial general intelligence, which would be human level, and beyond that, artificial superintelligence, things could change. I'm not so sure whether then, in a couple of years, maybe we will get what we would call human intelligence.
Yeah, well, on that one, there was a discussion at the EU level a few years ago about attributing personhood to AI once it reached to a point that was really kind of like human-like. And that proposal was rejected, I think with good reason, because, I mean, maybe things will change dramatically and I'm just, short-sighted. But to assume that AI will be able to exercise judgment in a way that is human, because, like, think of arbitration. Arbitration has one of the attributes that is, quote-unquote, confidential, or at least, not fully public. So to begin with, you have only a small subset of decisions available for the AI to make a judgment, or a probabilistic assumption. And if you go to Gismondi, for example, you will see that the majority of the decisions that are public are, about jurisdiction or things that, died, early in the procedures. Obviously, merits decisions on ISDS, but when it comes to the commercial universe, the decisions are actually quite limited. So how can this really make that, hip to, something that is human?
Jeremy, you wanted to add?
Maybe just very briefly, there was a question raised this morning to the government lawyers on the panel. How do you choose your arbitrators? And the thing about arbitration is you get to select the individuals, and so you are selecting their experience, their judgment, but also their values, right? So in this particular case, you might say, I want an arbitrator who had this government experience or has this experience interpreting treaties, because I don't know where he or she will come out on this interpretive issue, but there's a methodology that he or she might use in interpreting customary international law. So if you get to choose the individual, his or her experience, background, and values, and then you add AI to that, are you not in some ways transferring all the values, the things that you wanted to get out of this process to a different set of values? And I just wonder if we might lose some of the essence of what has made arbitration so successful to parties if it becomes collectivized in that sense. Thank you.
Two very quick points. One is how, and my experience is commercial cases don't generally turn on assessments of credibility, but sometimes they do. How on earth can AI make that assessment? Now, maybe there will come a point in the future when it can, when you'll have a robot AI that can look at the witness the same way an arbitrator can and make an assessment. And the second point is there is currently a case in California where an arbitration award is being challenged on the grounds that the arbitrator used AI to write the award. Steve, you probably know about this because you know about every case. Maybe you can tell us about it afterwards. But and it wasn't a case where there was an AI hallucination, which would be easy. And that's happened to some judges in the United States. They've issued opinions with made-up cases. hallucinated cases because their law clerk relied on AI. There was some, in this case in California, there was some inference to be drawn from the record that the arbitrator relied on AI, and so delegated, in this case it was a him, delegated his arbitral duties, sole arbitrator case.
Yeah, that's really interesting. I think, it's been suggested that maybe AI, once it gets to the level of human intelligence, can do what a human would otherwise do. And Klaus and I had this debate earlier, and I'll just recount one perspective, which is, I guess the question I have is, can AI ever be a proxy for a human determining what is a just outcome? Now, we may be okay with, at some point, AI making a determination on our behalf, but one perspective is, certainly my perspective is, and again, it may be that we agree that AI can make a decision, but the question is, will it ever be just in the eyes of a human? Because ultimately, I think what is just is a human concept. It is something that will evolve as humans evolve. I mean, you have seminal cases in the United States, Brown versus Board of Education, for example, where the Supreme Court fundamentally changes the law, and if it was AI making the decision, the law wouldn't change, or maybe it would change, but it would change at a different rate. Because AI would be predicting how humans might define what is and is not a just outcome. But ultimately, what is and is not just is defined by a time and a place and how humans view the world in that particular time and place. So I'm not sure that AI, even if it gets to the level of human intelligence, can ever tell humans what is and is not just. But that doesn't mean that it won't be making decisions for all of us at some point in time.
Just to pick up on that, in the 1970s in England, this phenomenon arose where juries would not convict people who killed someone as a result of drunk driving. When the choice was finding them guilty of murder or acquittal, they would routinely acquit them. Why? Because they, as tragic as it was, as awful as it was, they thought that the designation murder and the mandatory life sentence that would accompany it wasn't fair to bestow that on a drunk driver. So the law changed. As a result, there emerged a new crime called, I think, death by reckless driving, which still carries a significant penalty. But that is the human element at work. Who knows what AI might have done? I mean, in some sense, mechanically, the law is the law. Killing someone when you're drunk is as bad as, or close to as bad as killing someone recklessly, as bad as killing someone recklessly. And if it's reckless when you do it, when you're not drunk, and it's murder then, why shouldn't it be murder otherwise? But juries wouldn't do it.
Focusing on the change of law situation or the evolution of law, as we were discussing about this, I thought of Francis Fukuyama back in the day, predicting that history was coming to an end, with liberal democracy being the only relevant force. And in a way, if we are assuming that AI will kind of like just focus on past patterns to decide cases, we could be saying that law is coming to an end because you are effectively creating a kind of like stare decisis that international arbitration never intended to have, and even more so as a Latin American person, it's even worse because you are importing or you're establishing through the back door a stare decisis in a legal system that simply does not envision that. It's actually against it. Like if you look at the Chilean Civil Code, for example, it says that judgments are only relevant to the case at hand. So if that's the outcome of using AI extensively, repeating patterns, you are actually changing the whole architecture of the legal system.
Yeah, very interesting to say. I want to move to the counsel's role, but before I do, one analogy that I thought was really interesting, and Klaus, I don't know if you want to speak to it, was the role of arbitral tribunal secretaries in AI.
Not so much the role of the secretaries, but what I think is when we ask ourselves, how can we delineate admissible tasks performed by AI from non-admissible tasks performed by AI, my answer would be that is not a new question. We have that question on the table for many decades. It's the question as to the proper use of secretaries. I had a discussion with some arbitration colleagues from Sweden and the UK on Friday in Vienna, and I talked with them about the subject, and the colleague from the UK said, yeah, just take Article 14A of the LCIA rules, which deals with secretaries, and substitute secretaries or AI, and then you have a rule on how to deal with AI in arbitration. And I wouldn't be surprised if sooner or later we would have a 14B, section 14B in the LCIA rules dealing with exactly that subject. And in the recent issue of the ASA bulletin, the bulletin of the Swiss Arbitration Association, Anne-Kathrin Hahn, a Swiss arbitration lawyer, draws exactly that parallel and says, well, that decision is not new for us.
I think that's a really interesting example, at least for now, when we're looking at how to think about permissible or legitimate uses of AI. So turning now to the question of counsel, Felipe, you gave me an example recently, which maybe you want to recount of, a client coming to you and having their own ideas or having used AI in a particular way.
Yeah, exactly. A couple of weeks ago, I was with a client in the technological world, and they were actually super pumped that they had come up with a bot that was able to draft responses to complaints from consumers, basically. And they were aiming to have the bot draft 75% of the complaint or finish it up to 75%. And then the law firm that back in the day used to be the one who would draft the response, would only be tasked with confirming that the work of the bot was right. So there you see kind of like a clear situation in which still for simple cases, if you like, but a client is actively using AI to cut costs, and in that case it's working. Now, I think we all, in some form or capacity, have used AI to review a sentence or the like. So maybe it is true that when it comes to to the writing work in an arbitration, we'll use AI. But starting from that, I just want to say that if you think of hearings, that's maybe an area where that's not happening. I mean, of course, we have simultaneous translations or whatnot. But as John was saying, the ability of an arbitrator to look, at a witness in the eye and say, well, this guy is lying, or, the ability of counsel to stop a line of cross, at the right time, or things like that have largely been untouched by AI. And I think that that's by definition, because the hearing is really the place where, human interaction is at its best. And I think probably there is where, most of the practice will continue to live in the way it is today.
I mean, one thing that I found really interesting, we talk a lot about bias, right? Folks who are concerned about AI talk about bias, which there obviously is because AI, is only as good as the information that's input into it, but humans also have bias. So I wonder whether there's a role for AI, either with counsel or arbitrators, I'll go to both just to ask all of you, where AI can be sort of a check on human bias. Do you see a role for it in that regard? And certainly as counsel, I'll say, one of the things that we're starting to do is to test our own assumptions about a case by using AI and saying, look, what are the weaknesses, what are the strengths, and to trying to assess, is what we think is a strong case, or are the weaknesses in the case the ones that we think are the weaknesses in the case? So I don't know if you see a role, or if anybody has any further comments on that, a role for AI to maybe test human bias.
Yeah. I mean, no.
I was just going to make what perhaps is the trite comment that it's on a 3-person tribunal, that is your check on bias, that you have 3 people, hopefully from different who have different viewpoints who will be able to discuss with you your viewpoint. AI and bias, I can see as an advocate, yes, your job is to win a case for your client and you want to come up with the strongest argument, put it in, see what it says. As an arbitrator, your role is very different. You're not there to win a case. You're not there to push a position. You're there to figure out, based on the law and the facts, who is right. And I'm not sure if AI can help with that, at least dispel bias about that.
Yeah.
I would much prefer to rely on my colleagues.
Yeah, and I guess from a counsel's perspective, because AI today at least works in a way that is probabilistic, you can actually use it for, exactly how you said, like, how likely it is that this argument would succeed, what are the weaknesses, what are the strengths of the case. I see a use for that, and especially, for example, when approaching a settlement discussion, you can effectively measure how strong you're going. Then the issue, and maybe it's a good issue, is that, of course, when you have settlement discussions, you still have a human element, right? Because most clients are emotional. They're not just going by what AI say.
Actually, yes.
So, yeah, exactly. So maybe in the one area where it would actually be quite useful, you still will find kind of like the human element in a way preventing it from acting.
Yeah. Jeremy, one thought you had, which I thought was really interesting, is how AI might help us develop the law, as counsel in particular. Do you want to speak to that?
Yeah, I think for me, one of the most extraordinary aspects of international investment law is how much of the law has been developed over the past 20, 30 years through cases rather than through lawmaking, like treaties. And a perfect example would be fair and equitable treatment, which is the most invoked and most used treaty provision in these cases, and the protection of legitimate expectations. So you have a case in 2003 in TechMed where a tribunal recognizes the protection of the investor's legitimate expectations as part of FET. 3 years later, and the SLUCA tribunal could say protection of legitimate expectations is the dominant element of fair and equitable treatment. And by 2015, it was recognized as the most important provision in the treaty. So the most important aspect of FET. So we have the most important aspect of the most important provision is not found in these treaties, but was developed through case law. And so we could definitely see continued development of the law through better access to sources. I think of the recent decision of the International Court of Justice in the certain Iranian assets case, and although they were interpreting reasonableness in the context of non-impairment rather than FET, they didn't introduce this three-part test for reasonableness, including a proportionality analysis, which seems very ripe for research, comparative law research, across other sources that counsel may not be looking to further develop the law, national court decisions. Now, that might not be welcome to states, but another aspect of this, I think, could be welcome to states, which is development of customary international law, which there are provisions in these treaties based in customary international law, and states like the United States and Canada and so forth invoke these customary international law principles. The ICJ says the material of customary international law is state practice in opinio juris, and you can find evidence of this through national court decisions, through legislation, and through official statements of states. And of course, we have thousands of statements of states through pleadings and non-disputing party submissions. The United States alone has submitted more than 100, probably 25, I'll be corrected, non-disputing party submissions, many hundreds of pleadings. But you cannot go to Jus Mundi, you cannot go to ISLG and ascertain what states are saying about these obligations. They can tell you what tribunals are saying. There's no digesting of state practice in opinio juris. Now, I think this is ripe for AI development, whether it's through Jus Mundi or just through counsel that are trying to make particular points about the content of customary international law. But right now, at least as I see it, it's very difficult to establish the content of customary international law in some of these provisions, precisely because it's so disaggregated and there hasn't been any digesting of state practice in opinio juris. So I think it's one area where we could see further development in the coming years.
Yeah, this is really interesting. I'm going to date myself here, but when I was going through law school, there was this big question about, is Westlaw and LexisNexis, are they going to do away with first-year associates because you don't need to go to the library and look up the cases and the case books, because now you can just type it in and it's going to pop up and in fact, it led to this whole universe of like new cases that associates had to read and a whole bunch of new work. And, Jeremy, when you're saying this, on the one hand, it's like, yeah, this is great. It's access to a whole bunch of information and analyzing it in a way that we hadn't before. But at the same time, it's new, uncharted, maybe not completely uncharted, but new territory where, good law firms and smart lawyers are going to say, look, why don't we do this? And it's actually going to create more work. So one question I had is, a lot of folks have been talking about how AI is actually a democratizing tool. It allows for smaller firms to have the same access and the same abilities as larger firms. Do we think that's actually true, or is it that AI is actually just going to create more work and more ability to argue more things for, innovative counsel? I don't know if any of you have a view.
I'll just say, I think there will be more work, but fundamentally the problem is still discernment. I think the fact that we can research so much more easily, for instance, investment arbitration, hasn't necessarily increased the quality of pleadings. You just have 50 different cases to look at. So I still think the fundamental challenge for counsel is really distilling the essential legal principles, not just adding another couple of hundred pages to your brief because ISLG or Jus Mundi have found a bunch of other cases that you think are relevant.
I think there's not more work, but different work. I think that the nature of the work will change that you have to perform as someone who represents a client. And if you speak about democracy, there can be cases, of course, in an arbitration where there is no democracy between the parties because there is a severe imbalance in terms of AI sophistication. One party has a fantastic AI tool at hand, and the other party has nothing, and then you realize that as arbitrator, and then the question, of course, comes up, what do you do? Do you have to interfere, or do you have to say, well, I mean, in the old days, one party had Westlaw, and the other party had not Westlaw, and nobody cared. So I think these are very crucial questions that will come up.
As we all know, there are a whole bunch of cases in the United States where lawyers have got into trouble for filing legal submissions with made-up cases, AI hallucinations. Those, with one exception, only one exception, involve small firms. Small firms, because they don't have the resources to check. They rely on AI. AI makes up a case. They get into trouble. There is one exception involving a big firm, and if you come up to me afterwards, I'll tell you what that big firm is, but I won't announce it from the stage.
Yeah, and then just maybe one final comment on this. Like the promise, as you said, is that a small outfit will be able to deliver the same kind of work as a big law firm, thanks to AI. Now, of course, as John said, the disparity of resources can still exist. And for example, I was telling you guys that a couple of weeks ago, I was at a panel in Harvard, and someone from Legora was explaining that they were considering having a charge for each prompt. And that would be a model. So, me at my fancy law firm can spend the whole day prompting the machine to find all the results I may want. But a smaller outfit with limited resources or a cap will not have that. So, you can see how instead of democratizing it, we'll create a new form of disparity. That being said, though, one also thinks, well, is that really different from what we have today? Like a tier 7 firm has different resources as a tier 1 firm. They have like different, teams, different seniority of the people involved in the cases, etc. So maybe this is just a reflection of the same disparities we see today, and there is just not true to a promise of democratizing or equalizing that AI is posing today.
The last sort of category that we wanted to briefly touch on was use of AI by clients. We heard one example of Felipe where, client is like, this is going to write 75% of the brief for us. Great. But there is an interesting development, and John, maybe you can speak to this, of instances where clients are using ChatGPT and other AI tools to basically get legal advice, and some interesting things that are arising in that context, John.
There is a recent decision by Judge Rakoff, a judge in the Southern District of New York here, very well-known senior judge, known to be sometimes a bit of a maverick, but actually a very, very good judge, very smart. But this case involved a client who received legal advice from his lawyer and then asked ChatGPT, Claude, asked Claude about the legal advice. I don't know if it matters that it was Claude, but it was Claude, about the legal advice. And then there was a subsequent argument that he had waived the privilege by putting it into the consumer version of Claude. The consumer version of Claude has all sorts of disclosures when you sign up for it, including this isn't necessarily confidential, it may be made available in response to a subpoena, and so on. And Judge Rakoff made two related holdings. One was, well, Claude is not a lawyer. So when you ask Claude something, there's no attorney-client privilege. And secondly, because of the nature of this particular Claude, it was the consumer version, you had no reasonable expectation of privacy because it said in the small print that, you know, this could be publicly disclosed. I was recently in Brazil and at a conference, and I mentioned this case to a Brazilian lawyer, and he was delighted. I said, why are you so happy? He said, well, now I can tell my clients that they can't ask AI about my advice. They have to rely on what I tell them, because if they do, they run the risk that they'll waive privilege. And I said, but this is a New York case. But in any event, I mean, it is a risk. I suspect if you're using a closed system, unlike Claude, then you at least have a reasonable expectation of privacy. But attorney-client privilege with an AI bot, I'm not sure.
But, I mean, we think this is a one-off case, but how many, like those of you who are lawyers, or how many of you think your clients have asked ChatGPT a legal question? I bet, yeah, almost everybody probably, well, I'll raise my hand. I mean, almost certainly when people are asking or thinking about legal questions, it's just so easy now to be able to put a prompt into ChatGPT and get what looks like a reasonable response, that people do it all the time. People do it all the time. And that could become discoverable. That could become discoverable. So clients, I don't think they're not attending conferences necessarily, listening to lawyers talk about, the risks about using AI. But we, all as counsel, I think, and arbitrators too, are going to have to confront this, no doubt, at some point when someone makes a request for document production of all the prompts they've put into ChatGPT, looking for legal advice about these sorts of very complicated issues. The last question I wanted to touch on before I open it up, 10 minutes left, to a couple questions, is about regulation. We have a number of different bodies out there regulating. The IBA is coming up with a set of guidelines on AI. The ICC is doing the same. Many arbitral institutions are coming up with, soft law on how to use AI or how not to use AI. Klaus, maybe you can speak briefly to the EU AI Act, which is a bit of a, I think your view is, failed experiment.
Yeah, exactly. We have this EU AI Act for quite some time now, and the EU praises this as the world's first comprehensive legislative artificial intelligence framework, and I'm afraid to say it's more an example of failed AI legislation. It's extremely complex, very difficult to understand, extremely difficult in its structure. It covers AI systems intended to be used by ADR bodies for researching and interpreting facts and the law, or applying the law to a concrete set of facts. And these high-risk AI systems are then subject to governance, risk management, accuracy, robustness, cybersecurity. there are lots of exceptions. For example, when you have AI that performs narrow procedural or preparatory tasks, they are not high risk, but the question is, what does it mean? Nobody can tell you. And the best indication of the fact that the AI Act is a failure is the fact that the person who was responsible in the EU Commission to draft the Act, Gabriele Mazzini, resigned, quit his job with the EU Commission because he thinks this is the opposite of what we wanted to achieve. It's essentially over-regulation. So I don't think that we will be able to regulate AI by law at this point in time. And what remains then are just the wonderful sets of soft law instruments that we find everywhere from almost every reputable arbitral institution. But these are more lists for discussions between counsel and tribunal, nothing more.
Let's open it up to some questions. Maybe we can get the mic right there. Kathleen, I see, has a question. And if others have questions, we can collect a couple and then we'll have the panel react. So if you can just stand up and go to the mics. Yeah. Kathleen, go ahead.
So I'm Kathleen Paisley. I have to admit this is probably not so much a question as a comment. I think that if you take a step back and you look at first principles, obviously the first issue when anyone is using AI is that you're sure it is a closed system and it is confidential and that it doesn't teach from your data. And anybody can do that. That isn't so hard. They're contractual terms. It's no different in that respect from using Dropbox. So if you've done that, then the second question is what can you use it for? Particularly as an arbitrator, because that's my current role. What can I use it for? And there I think that KP's point was exactly on point. We spent years, multiple years, thinking about what tribunal secretaries could do. And there are those who believe that because AI spits out a fancier looking document, that therefore AI is more convincing than a tribunal secretary. I don't buy that. I think as long as you follow the rules on tribunal secretaries, that's cool, as long as you've done step one. Now, the big issue is decision-making and also collaborative decision-making. So what is AI now today? AI, I have to disagree with whoever said it doesn't question. It questions like heck if you're using the right prompts, number one. Number two, if you've used Claude or ChatGPT or Gemini, particularly Claude and ChatGPT, since February 5th on a closed record like you would use in an arbitration, and it hallucinated, I'm very, very surprised. Because there was a sea change between the 4th and the 5th of February, and every day it seems to get better and better and better and better. It's terrifying how good it is and how fast, not how bad. And that's the real problem, is that it really is that good. Now, I don't use AI in my cases as an arbitrator, but I never use tribunal secretaries because I believe in the writing principle. Now, I may be tempted about the procedural history because that's not my favorite part, and the world will not end. But with respect to the rest, I believe, and when I sit with arbitrators who rely heavily on tribunal secretaries, I'm not a big fan, but that's the way it goes. But the one thing I just wanted to say, everybody says to me, oh, you're the AI person. One thing I would say to you is take a record from a publicly available ISDS arbitration, because you can often get the whole record. Put it into Claude, put it into an enterprise version, because you should all have them anyway, and then put the record in first, don't look at the award, and play with it. See what it can do. See what it comes up with as opposed to what the decision said, and think about it. And the other thing is, last point is, I tell Claude, do not be nice to me. I do not need to be complimented. Be objective. I don't want to be right. Be this, be that, and it obeys. I mean, it's quit telling me how much of a genius I am. So I think you really need, once you really work with it, a lot of your fears will be assuaged, except that the fundamental fear of what AI can really do. Now, it's, the The question of touchy-feely, can it do a motion, all that, I don't know, probably not yet. But pretty much everything else on a closed record, terrifying.
Thanks, Kathleen. And yeah, question over there.
Hi. Oh, thank you for the panel. It's I think it of course this issue raises more questions than answers, and my question is broadly to whoever has a comment on this. As Felipe said, you already find this push for clients who are trying to streamline their processes and get the most economic efficiencies in the way they go about their dispute resolution. In arbitration, as opposed to having a case before a judge, you don't have the sort of like structure of institution that has this duty, for example, to make sure to some degree that justice is done by, for example, not hallucinating cases, and judges will enforce certain disciplinary measures to keep the system clean. In this case, in arbitration, it's all party appointed, and because it is a creature of consent, my question is, I think we can expect clients to, for example, try to include the use of AI in arbitration clauses, trying to foster arbitration tribunals to lean on AI, or their parties to lean on AI because they think that that's going to make it cheaper. So from our standpoint as lawyers, where do you think is where we have to do the pushback against clients themselves into this world that is necessarily changing, but that as you've already mentioned, there are significant liabilities that come with the use of AI, while clients will probably still move forward and wanting their lawyers to use it insofar that can translate to a more efficient, streamlining dispute resolution process.
Let's just get Edna's question, then I'll just get the panel to react and make any final comments that they have.
So I'm just curious how many people are actually seeing in the first order something about the tribunal using AI. I never have. I have a new case, and one of the arbitrators just came off the Supreme Court of Colorado. He must have been using it. So he suggested we put in something in the order, which we did. And it said something like, it's a ICDR case, you could use ClearBrief or other similar tools, is what it said, to summarize documents, to find evidence, to site check, and increase efficiency. So we got a little pushback from the parties. They said, what does that mean, efficiency? Are you going to be deciding? I just wrote back and said, yes, we're going to decide. It'll be our decision. And they were fine with it. So now we have this order that says we can do all this stuff, which I'm not sure. Summarize what? It's not very specific. Summarize documents. So I'm just curious how many people are seeing in their first order something about using AI. And I guess this co-arbitrator is going to use it. I haven't decided what I'm doing yet.
Interesting.
Have people been seeing it? I guess show of hands.
Has anybody seen
panel?
a provision like that? Eric, Kathleen?
Interesting, not really.
Interesting. I think we'll see more of it, though. Let's start from the end and come back. Klaus, any final comments or reactions?
Well, to your question, I think from my perspective as a practicing arbitrator, it's of course wonderful if I have an agreement of the parties on the use of certain AI tools. I would certainly appreciate that, and I'm sure that we will see this in the near future, either in contract clauses or an ad hoc agreement during the proceedings. And in terms of Kathleen's concerns, I couldn't share them more. I fully agree with her. On my way to New York City on Saturday, I read a book review on an AI book, and the reviewer said, AI does not knock on the door, it kicks it in. And I think that is very important to bear in mind when you look at the fast development which we are facing.
Jeremy.
Thank you. I think your question raises an interesting tension, which arbitration, of course, is subject to party consent, but the arbitrators have a responsibility to issue a reasoned award. And so we'll have to find a balance going forward. What is a reasoned award in the context of AI, where the parties have specifically requested it to be used in certain respects? Thank you.
Yeah, I want to pick up on the analogy that is often drawn to AI and a tribunal secretary. There's actually another analogy to draw, and that is between AI and an independent expert, which arbitrators also have the power to appoint. You know, the thing about a tribunal secretary, first, you always have to get the consent of the parties, no matter what he or she does, under all rules. If you look at any of the set of institutional rules, you have to get consent, even if it's to draft a procedural history, which is fine. I'm not quarreling with that. But a tribunal secretary should never do anything, if you look at the guidelines, that involves the expression of a viewpoint or of an opinion. An independent expert can. A tribunal can appoint an independent expert, and she or he can express a view on a matter in dispute. However, there are safeguards. Most rules have safeguards. What are those safeguards? The parties will have an opportunity to comment on the output of the expert, and they will have an opportunity to question the expert. She can be made available for cross-examination. So perhaps that is the better analogy. If you're going to start relying on AI to produce the outcome of the case, let the parties comment. Let the parties put questions to AI. Just some food for thought.
Going back to your question, I think that the key word is liability. Because the world is changing, the ways in which we practice law are changing. What is not changing is the ethical obligations we have. We cannot contract out, competence. We cannot contract out diligence. So even if a client is agreeing with us using AI or is pushing it, as the company I referenced, ultimately we are the liable parties as lawyers. So that's, I think, for me, the greatest pushback. I cannot just close my eyes and assume that AI will do the job, because if it doesn't, I will be liable for it.
Fascinating conversation. Thank you so much. One point I do want to make is, whether we like it or not, AI is here, and AI is making certain decisions in your daily life. When you decide to return an Amazon package and you give a reason, AI is actually deciding whether or not to accept the return. So there are going to be some low-value disputes where AI is going to make the decision, and we're going to live with it. Obviously, we're talking about sort of more complex cases, and one question is going to be, for clients, for lawyers, for arbitrators, where is that line going to be drawn? Because it is a slippery slope. I think the line is going to continue to move as AI gets more sophisticated. We just have to be aware of the limitations of AI, what it can do, what it can't do, and what we all know it can't do is replace someone like Professor George Berman, who's been here for 50 years and is, as we all know, irreplaceable. George, I think you missed it, but everybody had very nice things to say about you at the outset of the panel, which remains true despite how good AI ever gets. If you can please all join me in thanking our panel.